Does everyone agree to being recorded?
Yes.
Yes.
Okay. Calling to order the meeting of the Chesapeake Beach Ethics Commission on June 29th, 2021 at noon. Next order of business is the Pledge of Allegiance. We have a flag here.
I pledge allegiance to the
The
flag
flag
of
of
the
the
United
United
States
States of America and to the republic
America
for which it
and
stands,
for the republic for which she stands,
one
One
nation,
nation, under
under
one
God,
God,
nation,
indivisible,
indivisible, with liberty,
indivisible,
and
justice.
justice
peace
for
and
all.
justice,
all.
and justice for all.
and I will tell you, it is much, much easier to be in unison when we're all in the same room.
What, Phil, I've lost you. We're losing you.
Oh, it is much easier to be in unison when we're all in the same room.
Yeah, I don't think we'd make it as a choir, would we?
Now, okay. Item A on the agenda is approval of the revised minutes of the June 2nd, 2021 Ethics Commission meeting. I think Sharon sent us the revised minutes this morning.
Yes.
Does anyone have any corrections or improvements?
No.
Peter wasn't there, so I don't have any either.
He sat in on the meeting.
Okay, well, Peter, do you have any corrections or improvements in the revised minutes?
No, I do not.
Okay, they are approved.
No.
All right, now I have the public disclosures. And I think we have, as usual, we are learning things. We will be, before the next time disclosures are required, we will have some revisions. What I propose to do first is read out the names of those which neither Ingrid nor I saw any omissions or deficiencies, and ask for a vote to approve those as, all of those as accepted.
That sounds good, Phil.
Okay, all right. Mahoney, Pardiak, Evans, Ferguson, Lamb, Listen Bigler. I'll pass on Sussman, I'll get back to that, he's done a revised. Clark, and pass on Hum, because she did a revised. Odell, Van Wagner, and
No,
Wall.
not Odell.
Okay, here, I should have said this. I'm for this exercise, well, no, take out Odell for now and come back to that. All right, so with that list, without Odell, any objection to deeming them as properly filed?
None.
None. Hearing no objection, they are deemed approved. My notion is that, all right, no, we got two more. We got Sussman and Hum filed revised submissions. Does anyone have any objection to their submissions as revised?
No.
Hearing none, they are approved. No here. All right. What I'm thinking is, before we go further, right? There's a large number of forms where there are omissions, either total failure to check boxes or some information not clearly presented. Like, for example, somebody puts down the name of the seller is just one word, a last name, or it's the VA without any clarification. My thinking is that we will send a nice note to each of them with the form of, that we think is defective. Well, if it's a Form D, we'll send them a new blank Form D and a cover that they will be able to sign and date, certifying that it's, this is a revision. Is that okay,
Yes.
Peter?
I have no objection.
Okay, so let's start with, actually, Ingrid, I have a question with Bodine. What was your point regarding Form B?
It's just a stock. It's a holding she has, and she listed it. She's not an officer or director. She's just a shareholder, and it sounds like it's a DRIP program, which is
Yeah.
a dividend reinvestment program where you can just, put
Oh.
little drips and drabs in it as the
Okay.
dividend paid, they get reinvested. So I don't think she really needed to list Xylem. It's a common
Okay.
stock. It's
All right.
traded.
But more,
So I think maybe she was just, making sure she covered all her bases and put it in there, but.
Yep. okay, so it's not defective necessarily, nothing to refer, okay. All right, so we ask Bodine for on Form A, there's an omission of who she acquired the property from. Fink, Form D and Form F both have omissions, failure to answer everything. Black welder, Form A loan holder is missing. Brown, Form B is blank. Green Gold, Form A doesn't identify who the property was acquired from. Form J is blank. Jakubiec, Form C is blank. Form D, the last two questions are blank. Form E is blank. Larson, for some reason, didn't use a standard form. At least it's clear that he didn't provide the information required by Form A and Form D. Doherty, Form D, last three questions. Rutke, Form D, last three questions. Rutke, also Form F, first question is unanswered. Keat, Form D, two questions were unanswered. Getman, Form A, there is some omissions on, I think it's with respect to the value of the property when he bought it and the name of the seller from whom he bought it. Form D didn't answer all the questions. Hartman, Form A doesn't show previous owners. Form D, several of the questions are unanswered. Soroka, Form A, doesn't identify who we bought it from, doesn't show lien holder or co-owners. Form B, not answered at all. Form F, second question not answered. Barry on Form D is unanswered. And then I have note that on what I downloaded on Form A, some of the information isn't shown, but it looks like he typed it in. It just doesn't, the way the program is set up, didn't fit in what we can see. And I guess we got, I don't know well, let's come back to that. Let's get the rest of these. Castro, Form D, several questions unanswered. Form F, the second question unanswered. Newton. Well, no, Newton is separate.
Yeah.
Um,
I have a question for clarification. This is for my regarding Newton.
Mhm.
And I have the same question for Pounds later down the list.
Okay,
That's the town engineer and the town council. And I think both of them answered the questions pertaining with deriving income in some form or another from services to the town.
yeah,
In I think they've answered these questions in the wrong way, and I cannot find the forms in a hurry here. They are in my somewhere in the memory. My question is: is there a special understanding with respect to these professionals that they are excused from making that disclosure?
nope. But can we hold that, come back, get the easy ones and then come back to the substance here. On Pounds, he gives an address, but doesn't say what town it's in. All right. So now leaving the fact that we have some other questions with respect to what I've just recited, is there any objection to sending each of these a note with a copy of, or a clean copy of the form that's deficient and a cover sheet that the person would sign certifying the correctness of the answer, and ask them to just email it, or, well, I guess, yeah, email it back. Any objection to that?
No,
Okay. Now,
No.
okay, going back, let's take, let me find Newton. My note, only note on this was that although he personally doesn't live in Chesapeake Beach or anywhere near here, he lists 4 properties on Form A, doesn't provide the addresses.
But Phil,
It doesn't have to do that.
Phil, who
Yeah.
you're talking about?
O'Neill, I'm sorry, Newton. Which is, he submitted in the name of Message Group Incorporated. If none of these properties is within 10 miles of the Chesapeake Beach town limit, he doesn't have to list them at all. But since he didn't provide any addresses, it seems to me we need to get that, add him to,
although Phil, he did answer Form A and he said, no. The question being, do you own any real estate within 10 miles of the town's boundaries?
you are correct, that's right. But then he he lists 4 properties. So at least I think we want to get clarified.
Sure, it can't hurt.
And by the way, I'll try to draft something which, is non-accusatory. Because, I understand how people made a mistake with Form D.
Oh, Form D was definitely our problem child, wasn't it?
Yeah. What happened there is, for most of us, I think, all the other forms, there's a question at the top, answer yes or no. And if you answer no, you can just go on to the next form. And this one,
Agree.
so, all right. And then let's see, Peter, which ones did you looked like they were deficient in
Yeah.
Newton.
No, but, well, Newton, he answered questions for Form B and C and D with no, and I think the answer should be yes.
Okay, all
Or
right.
am I misunderstanding something there?
Peter,
All
could
right.
it be that he answered it no because he's an employee and not the owner of the firm?
I don't know why he answered no.
Let's see how he signs his name
All
up
right,
here.
so why don't we do this, with respect to Newton? Just ask him to clarify B, C, and D.
He works for a group called Messick Group, Inc.
Yeah,
So,
Yes, and
but
he
he
is
does say
apparently,
president, though.
well, he is the president and he also seems to be a part owner.
Yeah,
Yes, he is a significant part owner.
okay, yep, I see it now.
okay, so we'll send him something bringing his attention to this apparent discrepancy and ask him to clarify. Hold on, I'm sorry, I need to check something. Okay. Now pounds, is that the same problem, Peter?
Yeah, yes, I think so. Yeah.
He also, pounds is a problem that he gives, his address is 201 Riverside Road. Doesn't say which town that's in. Let's see, Form B. C and D. Okay, same thing.
That's odd, they would answer it no, isn't it?
Yeah, but, that well, maybe our questions aren't clear enough. Well, I don't know if Pounds doesn't own in whole or in part a business that did business with the town. Then
Well,
B
the
is, correct.
Phil, the question in part is who was contracted to the town as town attorney? Is it Alexander and Cleaver or is it Todd Pounds? If it's Alexander and Cleaver, I believe that Todd is a principal of that company.
Okay.
And I believe that he has an ownership interest in it, in that law firm.
Okay,
If
gotcha.
Todd Pounds is the party who's contracted with the town of Chesapeake Beach as town attorney, that
See,
places a little bit different spin on it as to how the questions would be answered.
okay, yep. Okay, that's, we'll ask both of these people to clarify.
Fred, I can't remember, how did you answer those questions, B, C, and D?
You asking me?
Yes.
I don't know. Let's see.
Because I was like, well, what did Fred say?
Let me say, ethics. So which group am I in?
You're
Town
in,
staff?
Ethics,
I'm in ethics.
you're with the good people. Let's see here.
you answered no to B and C, yes to Form D, which is employment with or interest in entities doing business with the town.
Right. And that is because last year I was a principal and employed by Council Barinell, and Council Barinell is the entity that contracted with the town of Chesapeake Beach. And I'm counsel to the Ethics Commission and the Board of Appeals.
Now you didn't, Form B, you didn't own anything in the law firm, right? You didn't co-own the law firm?
Let me find Which group am I in?
You're in with ethics.
Ethics.
Ethics. Phil,
You're at the very end.
okay. Sorry, it's taking me a while to scroll here.
Take your
Okay,
time. There's no rush.
Okay, so which form am I looking at here?
B.
B. Start with
B as in boy?
Yep.
Um, The reason I'm pausing and hesitating is because at some point I gave up my ownership interest in the firm. I don't remember exactly when that was.
Okay.
Uh,
Why don't you look that up, and if it should be changed to yes, change it to yes. Otherwise, just leave
Yeah,
it as it
Yep.
is.
no, that's fine.
I think the same, Form C is basically the same, right?
Yes.
We lost Peter.
Uh-oh.
No.
But then also in part D, even if you are not a partner, you're a salaried employee.
Yeah.
Oh, and you marked yes. Okay, you're good. I see it. All right.
Are we waiting on me for something
Yeah.
else?
Actually, I think we need Peter. We lost him.
Okay.
He's out in cyberspace right now. Ah,
Okay. Peter's back.
you're back, Peter.
Well, man. Peter, you seem to be muted. Can we do something about that? How do you,
Oh, I see it. Yep.
when you're on
Peter,
my
You need
phone,
to unmute.
Okay. I should be.
okay.
I, I am unmuted.
Oh, no.
Uh-oh.
Peter, oh, there you are.
y- yes,
No.
I have my connect again. It looks like. Can you in fact?
Yes, we can hear you.
Oh, okay, very good. I just saw a note, my internet connection is unstable,
Aha.
which seems to be a true statement.
Okay, all right, next point here is that 3 of the submissions indicated that a family member of the filer is employed somewhere in the town or with someone with a contract with the town. I think we don't consider, there's no deficiency in the submission. I think this is next meeting or between now and the next meeting, we investigate whether there is any conflict of interest here. But for this meeting, I think all we're doing is determining whether the submission is complete. Is that okay?
Yes, that's fine.
Okay.
Yeah, yes, that's all right.
All right, now, let's see, it's on Jaworski. I guess, well, Jaworski, no, I'm sorry, let me dig that out. F. All right. He reports that he received 5 season passes to the water park at an estimated value of $100. We can decide later whether there's any, well, what if anything, if that violates the gift provision or requires a investigation of whether he participated in matters despite a conflict of interest. But Ingrid, I can't find your notes, Ingrid, but you're wondering whether everybody on the council received the same gift and why he's the only one, why didn't they report it? Is that right?
Yes, that's correct.
So why don't we ask, we'll send a note to all the other elected officials, specifically asking whether they got a gift, season passes from the water park.
I mean, maybe it was offered and they didn't accept it.
Yep.
We don't know.
Okay, let's ask all other officials, elected officials. That's great.
Doesn't say who the donor was.
Well, we're assuming it was from the water, by the water park itself,
Or the town.
or the town. Should we ask Larry? Yeah, I think we should ask Larry to clarify.
Sure.
Yes, I do think so. If it was the the water parks, if it was Maryland's intention to give free passes to all council members, apparently that's not the case. So it raises the question.
All right, good. All right, and
Well, and also the valuation too, because if
So,
yeah,
haven't lately, but
I
I'm
think it's
sure-
appropriate to put the question to him.
okay. And by the way, what I'll do is I'll circulate drafts of these, so they make sure that they do ask the right questions with the right tone. All right, Morris. Form B. What was your inquiry?
I remember when I looked at, let me pull that up again, because his form, it didn't look the same. Let's see, there's, just one second, let me find it.
I got your submission. Morris, Form B answers no.
And then
Oh,
he
did you? Then he answers the
had more
question.
information was one thing, which was kind of weird.
Yeah.
So he says no,
Right,
but then he fills in, name of
Yeah.
business, address.
right. Name of business owned does indicate, yeah.
And then further down, he indicates he holds a 51% percentage of the business.
Yeah.
Then further, there's NA. So
That
why
way,
are we completing any of it if it's,
Yeah.
if it's a no?
yeah,
And then the box up on the top part, on the other Form Bs, the box has, I think, another sentence or two. So that just looked a little goofy. The box on the top of the form, Phil, you've got Form B, then it says ownership of businesses. And then we've got our little note box.
yeah.
The other ones have another sentence or two. I didn't look at it side by side. And it was like, well, what version is this? How did that
Now, wait a
happen?
minute, I'm looking, I just randomly took Bodine's.
Okay.
As the exact same thing in the box. Let's look at our own ethics.
Let's see here. Maybe it was my imagination. Let me just I'll look at one of the other ones. No, it's,
Oh, wait a minute, time out. Here's what happened. The instruction is different. Appears to be for elected officials and appointed officials.
maybe that's it. Because I'm looking at, yeah, you're right. Because the
That's
other
it.
one's the elected officials, the box. So
Okay.
that's fine. But there's
Okay.
still the why we answer no, and then we put.
Yes.
Maybe
But
he.
that's, the answer to that, which I assume, but we have to get the answer from him, is just sloppiness. I mean, same reason some of us
We're
didn't.
trying to be thorough and just, didn't realize, well, he answered no, and that means he didn't have to answer anymore.
And also, I know it's something we need to do with the form. For example, here, there's a box to be checked for no. There isn't a box to be checked for yes.
Right, yep.
So that's just, next year
Yeah, we definitely need to make a couple tweaks,
yeah,
especially on Form D, our problem child.
yep. Okay. All right, I will draft communications. We have to work with Holly on, I guess, creating a cover, the signature page for the revised submissions. All right, if nothing else, we'll move on to the next item on the agenda. Okay. We have two pending complaints, and I'm going to try to address them
Hey, Phil,
openly without mentioning the actual names.
excuse me, Phil,
Yes,
before you get to that, you all should be receiving momentarily a revised Form B for me,
okay,
okay?
Yeah.
So just
So
want
we
to let
won't
you
have-
know it's coming.
okay. All right. On April, but I think in April 14th, a citizen filed a complaint about an elected official. After we discussed it on April 23rd, I sent him an email saying we're not going forward with it because there's no citation of any provision of the ethics ordinance. He responded on April 26th, making a similar complaint against the same elected officials. There's a little back and forth. We asked him to, again, in this case, cite the conflict of interest provision that was violated. He responded on May 4th without providing that information. Therefore, I have drafted and circulated, it's a draft dated May 31st, which announces our conclusion that there's no allegation of a violation of a specific conflict of interest provision in the current code. That's preceded by a couple of paragraphs addressing what I think is a natural understanding that an ethics code prohibits unethical conduct, and that a complaint, that anyone can file a complaint that an elected official is acting unethically. That isn't the case. The case is that the only thing prohibited by the state's model and state's requirements are certain conflict of interest, participation in light of conflicts of interest. We could, just as a side, we're free to, or the town council's free to amend the ethics ordinance to, bar either all unethical conduct or other categories of unethical conduct. For example, bar an elected official from making false statements about the result of a survey, but that's not in the law now. All right, so the question is, first, is there a consensus that we should dismiss this complaint because there's no allegation of any violation of a specific conflict of interest provision? Ingrid, Peter, either of you object?
No.
No, I fully agree with the reasoning in the May 31st draft response.
Okay, and Ingrid, you're okay with that draft?
Yes.
All right, there's,
Phil,
Yes.
if I may, I had sent to all of you a suggested revision to one of the paragraphs clarification, and I resent it out, I think, yesterday.
oh, I didn't see, I'm sorry. I am sorry. Which is it? What is it?
What's what the change
Yeah, the change.
is on the first page, the next to the last paragraph, the one beginning for better or for worse.
Yeah,
And then I essentially clarified, you had said, the only sorts of unethical conduct that is prohibited, let me see, prohibited participating in decisions when the official has some sort of financial interest. And that's too narrow. I
okay.
had said, as I rewrote it, the only source of unethical conduct that are prohibited by the ethics ordinance are one or I participating in matters when the official family members or certain entities related to the official have some sort of financial interest as in the financial interest of the matter, and double I, engaging in certain other conduct expressly prohibited by the town ethics ordinance. I draw your attention to chapter 25, public ethics, article Roman numeral 3, conflicts of interest of the town code for the specifics of the specifics of the conduct that is prohibited by the town's ethics ordinance.
I agree to that change. Ingrid and Peter
Yes, sounds okay to me.
is better.
Yeah.
Fine, yes.
All right, without objection, this letter, the draft of May 31st will be changed as Fred suggested. All right, that takes care of that. The other one is, I mean, the file on it is huge, but we don't have to look at most of it. We received on, it's got to be April 8th, I believe, an email from an appointed official. Said, please find attached a request for an advisory opinion. And then there's attachment. We responded that, boy, this looks really like a complaint because it's talking about something that happened in the past rather than a request for advice about something that could happen in the future. We sent that on April 21st. And the appointed official responded that on April 21st, that yes, this was it's a complaint. The lengthy document was background information on the complaint. The original information shows that what happened is an elected official contacted and appointed a member of a commission and expressed to him a belief that that commission member was guilty of a conflict of interest with respect to a particular issue. The commission member then simply resigned. And I'm suggesting, and that was before the complaint was filed. And I'm suggesting that we dismiss the complaint on the grounds that it's moot in the sense that the elected official obtained the maximum result that could be expected under the complaint procedure. And that's actually in our current rules allow that, but it's just a matter of common sense. If you object to somebody participating in a matter as a member of a commission, any logical thing for us would be to order them to stop participating. And that was achieved. Therefore, I think we dismiss the complaint. Ingrid, Peter?
It does seem that it's resolved itself from that standpoint, Phil. I mean, what more do we want to do with it?
Are you saying that the matter has become moot?
Yes, yep,
Uh,
Essentially,
essentially. You know, and the funny thing here is I personally, you know, as from the limited information we have, I kind of think the guy was not guilty of anything. But, you know, that's
that's neither here nor there.
neither here nor there. And we can use our time and resources and mental powers to deal with problems that, you know, need resolution. Right, all in favor, actually, I can read this. Yes,
I guess before we leave that, the only thing is, I guess, you know, from that standpoint, we could say, well, if we felt that it was done in error, should the person be reinstated to the commission?
okay, let's see. So add a paragraph saying that we may revisit the matter if the person is reappointed to the position.
I heard earlier that that member resigned. Now, once he has done that, we cannot retroactively
No,
make him unresigned, can we?
no, no, no. I think Ingrid,
So-
here,
If that member,
yeah. Ingrid, what do you want? What should we say here?
I mean, because I think the person has already been replaced, haven't they? There's no longer a spot open on
Yeah, I
it,
think so. Yeah,
even if we wanted to reinstate the person.
yeah.
So. Yeah, I'm not sure what any next steps would be then, because to
All
me,
right, let's
that's
just,
kind of the only resolution.
yeah. All right, well, instead, we'll go with the draft I circulated a couple of months ago. You want me to read it without the names?
Do we need to?
No, I don't.
Do we need to do that for Peter's sake?
Mm,
Peter, have
Uh,
you seen that?
Peter, do you have the draft, 2-paragraph draft?
do I?
Yeah,
Not right now, but I can come up with one.
no, let me just read it then without, but I won't say the actual names. On April 7th, 2021, before this complaint was even filed, an elected official achieved through informal efforts the maximum result that could reasonably be expected under the complaint procedure. Therefore, without making any decision whatsoever regarding the merits of the complaint or the former member's defenses, we are dismissing the complaint as moot.
I don't have any objection to that, Phil.
Okay, Peter?
No objection.
Okay. Hearing no objection, this decision of the commission is to dismiss the complaint as moot and send a message to the complainant and respondent that I just read. Next item on the agenda is consider a pending request for advisory opinion. This was requested by email on June 17th, 2021. An elected official asked whether there was any conflict of interest or any other ethical infraction if 3 members of the town council and a member of the Planning and Zoning Commission travel together to the town of St. Michael's.
Phil, was it 3 or 2 members of the town council?
She starts with 2. Then the next paragraph is, we hope to invite a 3rd town council person.
All right.
Now, so it's either, well, it seems to me, I don't see any ethics code implications here. They may or may not be a violation of the Open Meetings Act, but we have no expertise in that.
I agree with that, Phil. It's if anyone, if there's anyone to whom this question should be, town's legal counsel.
Town council, yes, all right. So I will send,
Yeah.
if there's no objection, I'll draft and circulate this morning or this afternoon. But it'll say, we don't see any conflict of interest provisions being violated. If you have a question as to whether there'd be a violation of the Open Meetings Act, please consult the town attorney. So any objection to that course of
No.
action?
No, agree.
Decision is to send a message, adopt that as our message and send it. All right. Consider for adoption certain proposed changes in the rules of procedure. Obviously, I've got to have copies of that somewhere.
Thank you for your suggestions, Fred.
You're welcome. Happy to provide them.
All right. There's 2 new provisions I'm suggesting on page 5 at the end of section 6, which is complaint procedures. Sorry, yeah. First one, a new paragraph 14. Unless the commission grants a request to keep particular documents confidential, or if the Maryland Public Information Act would preclude disclosure of a document, the complete complaint record will be made available to members of the public upon request. What are people's thoughts?
I don't object.
No, in fact, I think we have to say something like that. I mean, we cannot cannot have a secret star chamber proceeding that the public cannot see.
Yep.
Yeah, Phil, I think the comment I made at the last meeting, if I recall, was whether this should kick in only after all proceedings are concluded by the commission, or if somebody files a request while matter is still pending before the commission hadn't acted on it, whether you're still obligated to and should be obligated to provide, the case file up to that point in time.
I don't see why not. I mean, maybe, so all right, so let's say a complaint's filed and a couple of days later, we get an email, well, I'd like a copy of that complaint. In fact, we had something like that, but I think we ignored it because I didn't know what to do. I suppose what we would do is immediately ask the complainant and the respondent if either of them had any objection to disclosure of the file at that point. Right? So, and if not, then there's no problem. Otherwise, the first clause of the section unless the commission grants a request to keep particular documents confidential, would govern.
Mhm. And I'm not advocating one way or another. It's just I wanted to get that thought out to the
Sure,
commission
yeah.
again today for conscious deliberation and decision.
I know, is it cleaner to wait until it's settled as opposed to midstream?
What benefit is the secrecy? I mean, the secrecy is ought to be for the benefit of somebody. But if, either the complainant or the respondent, and if neither of them objects, we're not hurt by it.
I guess that's true. I mean, if we're asking them and they don't mind, then sure, open the file.
Phil, thought, because nowhere here does it say expressly or explicitly that you will, seek guidance from the parties to the proceeding. So what you said, unless the commission wait a minute, comma, after notice to parties to a proceeding, comma, grants a request to keep particular documents confidential. So at least there's something there reflecting, an intent and expectation that the commission will reach out when it receives a request for documentation.
All right, why don't we do this if there's no objection? Let's not vote on this today. Either I or Fred will circulate a revision along the lines that Fred is just suggesting, and we deal with it at a future meeting.
That's fine.
That's okay with me.
Okay. All right, Fred, I think I'll draft and send it to you.
Sure.
Opportunity. Okay. All right, the next one is, I know Fred has some thoughts on this one for sure. The commission can reconsider any decision it makes under this section, except if doing so would harm a party which has justifiably relied on the decision. I think that's an inherent, it doesn't have to be put any black and white. But for example, we made some decisions on complaints today. Based on what we believe to be the facts, and theoretically possible that one of the parties will say we missed a key fact. There's nothing that we're not required to reopen, but if for sure, for example, in one of the cases, the complainant had cited section 2517D or whatever as, and at least on the face of it, that refers to the kind of conduct he's objecting to, and we simply missed it. I think we don't have to reopen, but I think we do have the right in the interest of justice to reopen. Fred asked the question, what kind of decisions are we talking about? I think it would be anything we decide.
And I think, Phil, that's only appropriate. And some of my suggested revision went to that point because some interim determination is not necessarily a decision in the technical sense.
Yeah.
So that's why I suggested adding or decision or determination to the language.
Hold on. All right, okay, so unless there's an objection, the text here is amended to add or determination after any decision.
Well, Phil, do you want me to read? Because I sent
Yeah,
this
read
out
the whole
again.
thing.
Yeah,
Yeah.
let me read the whole thing with my other suggested revisions.
Okay,
The commission, upon its own initiative or upon request of a party to a proceeding before the commission, and for good cause, may reconsider any decision or determination it makes under this section 6, Roman numeral 6, unless doing so would unreasonably harm a party who has justifiably relied on the decision or determination. Any request for reconsideration must be made within 30 days after the, actually, I should say, after the commission's initial decision or determination.
Yes, Fred, that's the language you sent out yesterday, as I recall.
That's correct. Yeah, I
Yeah,
sent it out yesterday morning.
Mhm.
I guess one question I had is 30 days long enough?
yeah, just,
And that was a placeholder, for your discussion and consideration.
Okay.
30 days is, fairly typical, in judicial proceedings and in other things, for reconsideration. But there's nothing that binds you to 30 days. In my own sense, is that it ought to be some finite, reasonable period of time so that matters, just don't drag on, with the possibility of change, on infinitum. You think if somebody is keeping track of, what's going on in a proceeding, that they will know or should reasonably know or be aware of what's going on. And if they see something wrong, they're going to speak up, reasonably promptly.
well, so somebody, we make a decision today and somebody 4 or 5 months from now asks us to reconsider, one of the factors would be, by delaying it, delaying the request, which is latches, is it some technical legal term? You waited too long, we deny the request to reconsider.
So I guess the question is, what is too long? Is it 60 days? Is it 90 days?
Depends on what the decision is and the reason for the delay. I'm gonna, if it's okay, let's put this off until the next meeting and think about the points everybody has made.
Okay.
Peter, is that okay?
It's okay, I agree.
Let's see, before I forget, I want to say out loud my deep appreciation for the work that Ingrid did, reviewing the disclosures. It saved, I don't know what kind of mess we would be in if we didn't have that to, as a starting point.
You're very welcome.
Not even a starting point, and 90% of the finishing points. Thank you.
Glad to do it, Phil.
Okay. Next meeting of the commission. I know I'm going to be out until July 11th. Other than that, I think I'm pretty free in July. At the moment, as far as I know, we don't have any big, well, here's the deal. Wait a minute, let's think about this. We're going to ask people to resubmit omitted forms.
Time are we giving them?
Yeah. Today is, what day is today? Today's June 29th. Obviously, we should give at least 2 weeks, don't you think?
Yes, I agree. Especially
No,
holiday.
it's vacation time and
Should we say the end of July and just give them plenty of time?
Yeah, because we made out, and that may not be a full month because it depends on the mechanics of, the optimum would be to have the person be able to go online and obtain the new forms. I'm not sure that's practical. So, so that's all right. In any event, we'll give them to the end of July, no matter when we get the documents out.
Okay, that seems fair.
Under the rules, I can call a meeting anytime, but I think there's no reason to meet before August then, right?
Phil, for long-range planning and my availability, I am having hip replacement surgery on August 17th. So I'm going to be out of commission for a little while. Won't be driving, they tell me, for 4 or 5 weeks.
Ooh.
After that, I'm told that I should not really be doing anything intellectually heavy for a few weeks because of the pain medication, et cetera, et
Oh,
cetera.
I see. Yeah, yeah.
But you guys know me, I think, well enough, to know that I'm not going to be able to stay away from my computer. But we'll see. Yeah, maybe I will be in so much discomfort that I will stay away from the computer for a couple weeks. But
Yeah.
so I just wanted you to be aware of that
All right,
timeline.
so that suggests we meet in the first 2 weeks of August.
That sounds fine.
Let me get in my calendar. Hold on.
That's
Peter,
okay.
that work for you?
Hey. Oh. What about for me?
The first 2 weeks in August, will you be around?
Yes, I will be.
And what about you, Sharon?
Well, I'm on vacation the first week of August, but
Well,
that doesn't matter. I can still get on the meeting.
That's up to you. I mean,
Yeah, it doesn't matter, whatever y'all decide.
Phil, you may not have heard Sharon say she's on vacation the first week of August. She says
So
she could tap in if need be.
Why don't we do the 10th in the second week?
That's fine.
What time?
1 o'clock?
Okay. Is it going to be live down in Chesapeake Beach, or are we going to be virtual?
I think it's live.
Well, why don't we have you, we could tap in, we could bring you in on virtually, Fred. Is that better?
If it's I don't know, can you have the capability for part live, part virtual?
Yeah, we'll double check that. I assume the answer is yes, but we'll work with the town and get that confirmed.
And let me just make this observation. If the purpose of the meeting is just to kind of review the financial disclosure filings and just finalize a couple of rule changes we've talked with, nothing really heavy and substantive, more substantive than that, then I certainly don't mind getting patched in. But and this is the same thing I'm telling all my boards and commissions. If, however, it's something of great, much greater substance,
Yes.
I'd probably prefer to be there with you all and interact face to face.
I would prefer that, quite frankly.
Okay,
So there'll have to be an agenda, and some kind of judgment, I guess, really just by Fred, whether we're asking for legal advice that on a substantive issue that we would be.
let's play it by ear. But in the meantime, if you all can check, and Sharon, you can check whether it's feasible to do part live, part virtual. We can make a decision on that at a later date.
That's great. Okay. Next item is comments by commissioners or members of the public.
Enjoy your summer.
Hearing none. All in favor of adjourning indicate by saying aye.
Aye.
Those opposed, no. The ayes have it. Thank you, everybody.
Thanks, Phil. Thanks.
All right, be well, everybody. Be healthy and safe.
Thanks, Peter.
See you in August. Take care. Bye-bye.
Bye.
Bye-bye.
Bye.